you.
And we're live.
Great.
Yeah, absolutely. So welcome everyone to our Impact Speed Date. Today, Carla and I are so glad to be welcoming Laura Clatworthy, who's a partner at Rosenblatt law firm. And we're going to be covering a topic which is on a lot of minds. We're not quite sure where it's going. It's shifting all over the place. When we think we have it figured out, we realize we don't. So we're going to be covering the topic of the evolving law around crypto and digital assets. Now, Laura's got quite an extensive legal background, has started in the digital assets and crypto space purely out of interest in blockchain and the potential of the technology. So it would be absolutely fantastic, Laura, if you could share a little bit more, just an intro on yourself and how you've gotten into the space as a lawyer, because it is a relatively new industry, so to speak.
It is. So I'm a disputes lawyer by background. So I'm a commercial disputes lawyer. But I got into blockchain, as it was called back then, about 6 or 7 years ago. And that was actually through a great guy that I worked with called Adrian Harris, who retired a couple of years ago, who I spent the last 5 years of his career working with, who was a restructuring lawyer, and he'd headed up a couple of US law firms over here in London. And he was a bit of a mentor for me, and he'd had a lot of practice in building businesses and creating businesses, and he was kind of mentoring me in terms of business development and career progression and things like that. So he was wonderful, and he actually started talking to me about blockchain, and then my partner, who's a corporate lawyer, was also interested in crypto. So I was having conversations with both of them about crypto and blockchain. And the three of them, by the way, my partner also works in the law firm I'm with as well. So basically the three of us set up almost like a working group, and just through our personal interest started reading about the technology, what it could do, how it could work. And we started meeting startup businesses, incubators and accelerators in the space. Just started reaching out to the pretty small network that was in London at that time of businesses working in blockchain. And then that sort of then developed into where I am now. I've sort of carried on pushing with it over 6 or 7 years, and we've now got quite a good reputation in the space. Just carried on following the businesses, going to conferences, following the law, and then gradually building up quite a large network of players generally in the space.
Yeah, that's awesome. I mean, it's an area in itself, but you're practicing other areas of law as well. How is it, we'll get into the nitty-gritty in a minute, but how is it that you manage to keep track of what's happening in the space with it evolving so much? And because it's international in nature, you're practicing in the UK. How does that work for you?
So I have to say, a couple of years ago, and it just kind of exploded. And when NFTs really took off, and suddenly people talk about, the metaverse was really starting to take off, I did feel like I was running to try and catch up with everything. To be honest with you, lots of things were developing. It got a bit too much. So I've got a great team. I work for a firm called Mariappen and Rosenblatt. It's one law firm with 2 brands, and what I've got there is a team of people in different practice areas, who I work with and who go off and keep up to speed with developments in their area, and then we talk about it and we discuss it. And as a litigator, I'm constantly having to keep up to speed with different areas that are progressing. So I kind of just then keep up with those areas and keep the sort of level of knowledge that I need in order to understand what's happening, what's going on, and then I call to my specialists to give real detailed understanding of particular areas. So for example, I've got great funds and regulatory partner who I work with, Daniel Tunkel and his team, and they keep me up to speed what's happening in the regulatory field. I've got a commercial IP and IT team. I've got people there that keep up to speed with the development in Web3 and the underlying contracts and smart contracts and things like that, and they keep me up to speed with that. And then as a litigator, I've kept up to speed personally with the development of the common law in the UK around how crypto is defined, how it's dealt with through the courts, what rights people have in the courts to protect themselves in terms of the crypto they've purchased, and and enforcing those rights. So it's kind, and then so on the corporate side, obviously I've had my corporate team looking into DAOs and the development of DAOs and how that all works, and then again using my litigation hat, looking at where the risk areas are, and and where somebody, I think particularly in that space where when I first started talking to people about DAOs about 3 years ago now, they were coming to me and going, oh, we're interested in setting up a DAO because we'll be above the law. You're not above the law, and still kind
you're outside for a while, but
yeah,
it doesn't work that way.
It's always going to catch you up. So that was really interesting, looking at what the concept was legally. I was trying to think what they were trying to do from a legal perspective, and then working that through, and then looking, going, right, okay, so actually what you're doing is X, and that would mean you'd have these sorts of risks and liabilities. And so that's I really enjoy doing that, and tracing through what where people are creating new concepts, where that intersects with the law, and in fact where that intersects with various laws that wouldn't historically have crossed over with one another. That's really interesting.
Yeah, that's awesome. There's so much to unpick there, and we're pleased to have Carla Philo, who's co-founder and CMO, sorry,
Right.
of Impactoverse with us. So Carla, I know that you've got you have a number of questions as well, because we've been looking at DAOs, and there's so much around the regulation and jurisdiction that Laura mentioned, so feel free to chip in with your cues at any time. So Laura, because you'd spoken a little bit more about DAOs there, can you share what the current state of play is with DAOs in the space?
So I'm obviously speaking specifically from a UK, or even more specifically Wales perspective, because that's where I'm registered as a lawyer. So we've got this wonderful joint task force that's been put together in the UK called the UK Jurisdiction Task Force, and that, I think, is a really good place to start when you're talking about where we are in England and Wales in terms of applying the law. So this was a task force that was put together specifically to deal with developing the law for these new sort of crypto digital businesses, and specifically it's headed up by a chap called Sir Geoffrey Voss, who heads up the civil division of the courts here in the UK. He's very, very pro the creating an environment in the UK for these new businesses to grow and to flourish, and he understands, as do all lawyers working in this area, that in order to do that, you need to provide certainty, you need to provide discipline, effectively, that you need boundaries, and you need clarity, so that these businesses can come along and they can offer their services, and they can create their businesses in an environment where the person they're selling to knows that they can enforce their rights, and the people working for those businesses know that they can work within a certain environment, and they're not going to have excess liabilities forced upon them that would be very detrimental to being able to grow those businesses. So the task force has gone through a number of consultations in key areas of law, and one of those is DAOs, actually. So they've gone through a consultation process that they haven't actually issued the results of that consultation process yet, but effectively what they have said is that there are laws in the UK to deal with DAOs. Effectively, you are governed by the law. The laws are sufficient in our legal system to be able to flex and cover evolving situations. And where you are in a scenario where you are working together as a group of individuals, and you are effectively running an economic group, so you're effectively like a board of directors or an executive board, or you're working towards an economic purpose, that what you're effectively creating there is potentially a general partnership, right? And that's governed by the Partnership Act of 1890. Okay, so and I think this is where it's gone similar to actually where it's gone in the States. And if you are deemed to be a general partnership, then you will have a joint and several liability towards each of your partners and towards the third parties that you contract with. So that's a potential covering of liability. If you're running it as a charity and it's not for profit, then you may be an unassociated company. And again, you've got joint and several liability towards your fellow members and towards third parties at large. So effectively what you're doing by not setting up a limited company status is you're running a business effectively with unlimited personal liability is effectively what you're doing. And if your DAO is your DAO could be the whole company, or it could be a part of that business, because obviously I know people set up a DAO structure for certain parts, but that what they'll look at is the certain part that you're running, and they'll look at your responsibilities and liabilities in respect of that particular aspect of the DAO that you're running. So what you need to do when you're running a DAO is you kind of need to map out where the structures are, how they're being governed, what the governance is, and when you're going through that process, you'll work out where the liabilities lie. And there are other things, you've got fiduciary obligations. These are implied into relationships. You don't have to have expressly determined fiduciary duties. You could have fiduciary duties towards your clients, towards your the people that you work, the businesses that you work for, and those can and will be enforced through the courts in the UK if that's where that DAO structure is based, or the particular structure is based, and you have that reach in the UK.
So when we're considering this, and there are obviously the DAO structure is one thing, but when we throw in crypto into the mix and fundraising through crypto, and a number of players within that sphere, essentially the parties who are part of the DAO could be anywhere. And you have this overlap of, okay, how is crypto and movement of crypto assets governed, and digital assets? And then also, how do you enforce fiduciary duties and liability to parties who might not necessarily be in the jurisdiction? Is that something which is considered? How is that?
So that they are also about to launch consultation into jurisdiction, but there have been cases in the UK already about jurisdiction. So the one case, and they're at odds with each other actually, in terms of whether or not courts would have jurisdiction in England and Wales to hear a piece of litigation about a dispute, which it will be if it is being called into question. So the first one is called Iron Science, and basically that determines that where the key holder is domiciled is where jurisdiction will be. The second one, which everyone will have heard of, is tulip trading. And tulip trading, these are both at the same level in the UK. And the tulip trading has determined that it's the residence of the token holder which determines where the jurisdiction is. So effectively, if you are selling a token to someone through your DAO structure, and that person is resident in the UK, and that person in the UK has a dispute, that person in the UK will very likely have the courts in the UK determine jurisdiction to hear their dispute in relation to the DAO and the crypto or token or whatever it is they purchased through the DAO structure. So now that doesn't mean it's governing law, right? But you will still have that jurisdiction. But then if you've got jurisdiction here in the UK, what you've got is English law mentality overseeing the dispute. And then you will have to look at the underlying, issues involved and whether or not, when you're looking at governing law, and that would depend on the dispute in question. I have to think about what the dispute might be, where you'd have the relevance to determine whether or not there's been a partnership. But there have been a couple of cases in the States, for example, with Oki DAO. I don't know if you've heard about this. So Oki DAO in the US has had a determination against it that effectively found that it was a general partnership, and there was joint and several liability for the members of Oki DAO in the States. And then separately to that, there's a negligence claim being brought against the founder of Oki DAO and the DAO members that had a governance vote by the remaining members of the Oki DAO because they failed to implement a security protocol that they said they had done, which led to it being hacked. And so those non-governance DAO members are suing the others for $55 million. So, you know, it's so I think the bottom line is wherever the courts find jurisdiction, which they will do, they will also find the laws that will govern what you're doing. And even, you know, so if the partnership derives out of the US, in the UK, they'll say, right, well, it's a general partnership under US law. If it derives under UK law, they'll find a general partnership or, you know, or fiduciary duties or obligations under UK law, whichever way it goes. And it will obviously, I can't tell you now how that will be because you'll have to look at how the particular DAO is set up. But you know, they will then apply the laws that already apply to these sorts of associations. Where you find a group of people running a business, laws exist. You'll never be operating a business in a lacuna.
Yeah. Carla, I know that you will have questions around regulation, particularly in light of everything that's been happening in the US. Is there anything that you'd like to ask Laura at this point?
Well, I do want to move on to NFTs in a second, but I had one quick question because what struck me about DAOs when I originally was looking at the model was it's a co-op kind of.
Exactly.
So do you have, was that something that the task force looked at, like or to recommend that this is actually a co-op structure rather than a partnership, or is a co-op a partnership, or?
No, they didn't look at the co-op structure. I think the co-op structure has a legal status in the States. It doesn't really have the same the same sort of legal status over here in the UK. So they looked at whether it would be an unincorporated association, whether it could be a general partnership. They also looked at whether if you know, it could also be, for example, that the purpose of the DAO is to hold a single asset, for example, in which case it might be that you're looking at joint tenancy in common. You might be looking at a trust structure. You know, so it really depends on the purpose of the DAO, how it's been structured. You know, what you know, where the you know, what the perceived outcome is meant to be, whether you're dealing with securities, or all of this kind of thing is you're gonna look at how that in reality means that the DAO is being managed and run. But I you know, I think, frankly, if you're running a business for profit with a group of other people, it's probably more likely than not to be a general partnership, as opposed to anything else.
Okay, thank you for that. And also anybody watching this, I'm going to actually look into Spain and what they're doing around DAOs, because I think they have a really strong tradition of co-ops. So that might be a place, and the US as well, but as far as international goes.
Yeah, I mean, when I first looked at it, it made me think, right, well, that's just effectively a co-op, right? But
right.
Yeah.
Yeah, but you know, when there's money involved, it gets a little more complicated. So thanks for that. Yeah, I'd like to, if we can, talk about NFTs. And maybe one of the first questions I have is kind of to give, if we can, if there's hope for people who are working with NFTs, not as an investment, not as an asset, not buying them, you know, as a something to invest in, but more like Noleen and I are helping people promulgate NFTs as a digital you know, it's a proof of ownership, or it's a symbol, or it's a ticket, or, you know, it's not something that somebody's investing in hoping that it will go up in price, right? And so are the evolving regulations, I think in the EU, they came out with a set of recommendations, right? And there was some talk in that around, you know, NFTs as speculative assets versus NFTs as just like collectibles, basically.
Yeah, collectibles. Yeah, that's the word I use. Yeah.
So what are your thoughts on that?
I think the way that it's going in the UK, so a few years ago, we started talking about security tokens versus utility tokens. So it's kind of that separation, which I think a few people had difficulty in kind of they're moving away from that definition. But I mean, effectively, those are where the boundaries are, I would say.
Yeah.
And so I think the best place probably to look at that is at the recent notification from official notice from the FCA, which was last week, that it's expanding its expanding its regulations effectively to cover financial promotions over crypto. So we've had the AML regs that have come in. Again, then that, you know, our advice basically to all the people that we see is that if it's not effectively a security token, as was, you're very unlikely to be covered. You're very unlikely to need to have AML registration here in the UK, which is good because it's taking so long at the moment to get that. And the notice that came out last week had a definition of the crypto assets that were covered, which I'm just going to scroll down to now. So it's quite a large definition, and I was going through it before this actually to try and unpick exactly what it covered. And I think the conclusion that we've come to is that, again, effectively carves out utility tokens. So it covers so the qualifying crypto asset for the financial promotion order excludes money, so fiat currency, electrons. It excludes CBDCs. Again, it seems to be something that the FCA is not, you know, is carving out. It excludes those, and they have to be fungible, right? So if they're non-fungible, they're not covered. So again, this idea that it's linked to a non-fungible asset would mean that it's not covered. And it also carved out if there's a limitation on where you can exchange your tokens. So if you're effectively buying it in world, so for gaming in world, and you've got limited services and goods that you can exchange it for, that's also excluded. So it seems to be excluding money, NFTs, and gaming tokens that are not traded elsewhere, which seems to be something. There's a separate joint task force looking into the definition of crypto tokens last year, which actually has decided that in the UK we need a new definition of personal property called a digital asset, digital property, excuse me. And again, they've carved out this concept of the non-fungible token, right? So they've been very careful so far. Everything that's come out so far in the UK, they're sort of pushing to one side the non-fungible token. I think people see as being already governed by the laws that we have. So what they basically said in that that particular joint task force statement was that the non-fungible token was effectively the metadata underlying the token, and that the laws that we have already cover the contracts and the asset itself, right? So you don't need new laws to govern the ownership of the underlying asset, and then you've got contract law, which governs the smart contracts, and you've got the contract law in real world, which effectively govern everything relating to that asset, the underlying asset.
That's really interesting. So how do you feel about that, those developments?
Well, to me, it makes perfect sense, because you don't need. In the UK, they've been very, very careful not to bring in unnecessary new laws, but also I feel quite very, and I do feel very fortunate being a lawyer in the UK. But we do have the common law system we have enables the law to develop with changes in society. That's effectively how it's been set up. That's what case law is. When people say common law, what they mean is law that's been expanded upon by judges, and the case law that we have that you come through the common laws. And they've been, some of our common laws have been in place since 1800, and that's because you have a law that's set down in 1800, and then you expand upon it and you create it and change it to make it relevant to the current day, right? That's what we do. That's how law is developed, and that's how it's going to continue to be developed. What you don't need to do is throw it out and write a whole new law book, because that would create a huge amount of case law and uncertainty, frankly, weirdly. What you need to do is just say, right, what we've got are the laws that exist that govern this, and what you need to do is just have a couple of judgments that say, yep, that covers this. So what we've done actually with these joint task force statements, and this was the intention, I think, of Sir Geoffrey Voss, who's headed up the joint task force, is to effectively fast track that change in law in the UK. So rather than having to wait for a case to go through first instance Court of Appeal, Supreme Court, which costs a huge amount of money, can take time, they've effectively run these consultations in order to create the law at source, so that the barristers that are then fighting these cases can refer to the statement and can refer that to the judge, and they all rely on that effectively, and then it becomes case law. So he's effectively created the arguments for the barristers to put to the judge, and the judge is not going to disagree with the joint, and in fact they haven't, and they have applied it as if it were law, and then that's going, so that provides that certainty at source effectively. So you've cut out, you know, between 5 and 15 years of uncertainty effectively. Yeah.
Sounds like a very measured English way of doing things, and that's not how it's happening here. So there was a funny thing John Cleese said when we elected a certain president a few years ago, and he said the Queen's made an announcement, she's revoking your independence. You can't manage yourselves. And I have that feeling sometimes around how we're dealing with crypto in the US, where it kind of originated. So thank you for that insight. And what is encouraging is I think there is a lot, you probably know better than I, but a lot of international talk going on behind the scenes and also in front of the camera. But in the US, it's a balance of obviously politics here, the appearance of it, and with the implosion of FTX, that really set crypto back is on Capitol Hill quite a bit, because a lot of people had aligned themselves with the founder of FTX, and then that happened. And so a lot of politicians are backpedaling, which hasn't helped. And the industry itself hasn't done a great job kind of managing those perceptions, but there's great people working on it now. Blockchain Association, and so you know there's hope, and it's going to evolve and happen. But it's great to hear that you guys are making progress. In different ways.
Yeah, well, look, I would be lying if I didn't say that, you know, FTX and SVB didn't impact on the business. I mean, it has. I think mainly it's impacted on confidence in the products and confidence in the individuals, and that has been held back by you know, the regulators being slow to regulate, and I think that's, you know, universal, frankly. But we are gradually getting there. You know, could we and should we have got there earlier? My own view is yes, we probably should have and could have. I don't see, you know, they managed to do it in Bahamas, they managed to do it in Guernsey, they managed to do it in you know, Malta. Okay, Malta's, you know, but you know, they managed to do it. I don't think it's a, you know, all you needed was a few you know, intelligent people to sit down and write something to give initial certainty. But, you know, we're getting there now. And I think we're still probably a good couple of years away from being where we probably should be. But, you know, as I say, it's, and I think people sometimes miss this. It's not just about regulation, because there is a lot of activity in blockchain and crypto, which is around products and projects that don't need regulation. Okay, and those projects that don't need regulation, there are the laws there, the certainty to help you deal with that. And even frankly, if you know, even if you've been dealing with a company that you know, didn't need regulation and therefore was able to get away with some dodgy practices, you know, the court systems are there to help you with that as well.
Right.
That's encouraging, and I think there is hope. Where it's just it seems to be a moving feast on so much at the moment, and I think a lot of that is due to this degradation of confidence, and where something was seen as, you know, holding great potential, that is now viewed with great deal of skepticism. So I think all of this coming into play and gradually being worked out, even though it definitely could happen quicker, works in our favor. Absolutely.
It does. And I think what's important to say is that, you know, the legitimate businesses in this space have been crying out for legal certainty and regulation. They want to be regulated. They want to be able to say, yes, I'm complying. and they have struggled because they haven't been able to take their businesses forward in the ways that they want to because of that lack of oversight, and that I think is often missed by the public perception, because obviously that's not a good news story for newspapers. They want to report on the scandals, but unfortunately what doesn't get reported on are the businesses that have been working very hard to create legitimate businesses in a difficult environment.
Yeah, absolutely. And also, I think clarity around, regulation and compliance, not necessarily meaning that we are moving towards a centralized system again, and I think that people misunderstand that a bit as well. So we've had quite a lot to cover. I know we could probably go on for quite a lot longer with more questions, but Carla, is there anything else that you want to close off on?
Not that we can close out with, it's too big of a question, but I want to come back later if we have a chance and talk about the way crypto is developing differently in the developed countries versus the global south versus developing countries, because it's two very different things. And I just would be fun and interesting to talk more about that and how that's going to work out for crypto as a currency, a global currency. It's my opinion the US is a long ways from recognizing it as anything other than you're gonna another currency. It's not going to be accepted at the same level as US dollar here. I don't think anytime soon.
I don't think that's going to happen quickly, if at all, frankly. Who knows? I mean, I think we will get to a stage where we have digital money, just because the technology is there, right? It would be daft not to use it, because there are lots of
CB, central bank digital currencies, for sure. I think that's what a lot of the governments are looking at, and the global south is taking the lead in that. Was it Nigeria has Sandbox, the sand dollar, and it was one of the first ones launched, central bank digital currency. So anyway, as I said, we can't cover it all now, but I think that's fascinating.
In these developing countries, they want to do it because they obviously have
Bahamas. Sorry, sand dollars, Bahamas. But go ahead. Yeah. Right. Okay, that's all I had. Thank you.
Yeah, absolutely. So would absolutely love to hop on another. There's just so much for us to cover. But that's about it for us, or from us for now. Thank you so much for joining us. If you have any questions when listening in, please feel free to connect with us on LinkedIn or elsewhere. And we're happy to help support you on this impact journey within the Web3 space. Thank you so much, Laura. Really appreciate you being on, and look forward to connecting again soon.
Yeah, Laura, sure. Do you have a website or somewhere people can find you?
Yes. So you can find me on LinkedIn, Laura Clatworthy, or I work for a firm called Rosenblatt. So it's rosenblatt.co.uk.
Okay, great.
Wonderful. Thank you. Thanks for remembering that,
right.
Carla.
No worries.
All right, everyone,
so
take
much.
care. Thank you so much for joining us.
Oh, wait, one more thing we need to do we can do it off camera, I guess. A smiley face.
Let's go.
Screenshot. Okay, let's stop recording. I'm in charge of that. That's what happens when you put me in charge of. Okay, stop.